Good evening, and welcome to Legal Ethics and Professional Responsibility, Legal 259. Tonight, our subject is Chapter 8, Special Issues in Advocacy. But before we jump into the material, I have a few updates for you regarding our final. So today's our last session, and it's a recorded session, and so it will be available to you on November 29th, as we discussed in class. And the assignment for this week is due December 10th. So a significant amount of time for you to do the assignment. The final exam is scheduled shortly after that last assignment on December 10th. It's scheduled for December 12th from 3:25 to 5:25. It will be in our Canvas shell in week 16 module, and it will open automatically at 3:25. It will close automatically at 5:25. So be sure to be there on time to get the full 2 hours. It will consist of 40 questions, and they will cover chapters 1 through 7. So chapter 8, which we're talking about tonight, is not covered on the final, but you will need it to complete the week 15 assignment that's due on December 10th. Now, the final will be similar to the midterm. It will be 40 questions that are in a quiz format, multiple choice, just like the quizzes and midterm that you've taken before. So you should be very familiar with the style. And it's open book. So I encourage you to have the book or the table of contents of the book available for you to find topics quickly. Should you have any question or need some information about one of the questions on the final, you can find it fast. If you have your own outline that you've created, that could be even more helpful. It could be a little bit more detailed than the table of contents, but I suggest that you at least have those resources available to you when you're taking the final, so that you don't have any issues with identifying information that's needed to select the proper response. If you have a scheduling conflict, please write me an email in Canvas explaining the situation and suggest a 2-hour time block that you can take the exam on December 12th. Some other time in the day that you're available. If it's during our regular class hours, that's okay. If 3:25 to 5:25 somehow has a conflict, then please let me know, and also suggest a time that you can take the exam. Explain the situation. I'll be happy to do everything I can to help accommodate people who have conflicts. So let's jump into the material for tonight. It's called Special Issues in Advocacy. It's chapter 8. I hope you had a chance to read it. I'll be going over the topics that I find most important from the chapter. Most of what I found most important was in the early part of the chapter. The assignment that you have been given that's due on the 10th can be done with the material that we're covering tonight. So what are these special issues that we're talking about? So first of all, with regard to some context. So we all know that our country has become more and more litigious over the last 30 to 40 years. And with that, there have been more different types of legal specialization that's happened, and more attorneys who practice outside those fields where it's typically litigation and you have to go to court. So it's actually evolved to a situation where most lawyers nowadays don't go to court regularly. Corporate lawyers, tax lawyers, estate planning lawyers, real estate lawyers, intellectual property lawyers. There's a whole bunch of different types of lawyers that don't necessarily need to go to court. And if they do, not very often. But that's not true for paralegals. When you look at where paralegals are most prevalent inside the legal practice, it's supporting litigation. So supporting things that do go to court, supporting cases, supporting all the things that go with cases, working up the facts, doing discovery, drafting motions, responding to motions or responding to discovery requests, preparing for trial, figuring out what the facts of a case are, working with the client. All these types of things in litigation is where you find the majority of paralegals working these days. That's not to say that there's not a lot of opportunities for paralegals supporting corporate attorneys. I had paralegals, they did fabulous work helping me in a lot of ways. It's just identifying that it's interesting that for most lawyers, they don't go to court regularly, but for most paralegals, they're probably working to support litigation. There's plenty of opportunity for you to pursue whatever kind of practice you want to. Don't be worried about the fact that the majority practice in litigation. If that's not a field of interest to you, there's plenty of opportunity everywhere. Now, while lawyers have a duty to represent clients zealously, which is an ethical obligation or a duty that we discussed in an earlier class related to competence, they are prohibitive from doing the following things. They can't, in that pursuit of zealousness, they can't bring unmeritorious claims or unmeritorious defenses to claims. By model rule 3.1 in the ABA model rules outlines this. Be sure to check whatever jurisdiction you're in to see how they've adopted some form of model rule 3.1 or revised it to meet their needs in whatever jurisdiction it is, but it probably is the same basic rule or components to the rule. But to help protect the legal system, protect its integrity, allow people to access it when necessary, to keep the costs reasonable, all types of things like that. Lawyers are not allowed to bring unmeritorious claims or defenses. They're not allowed to create unnecessary delay in the process. That's in Model Rule 3.2. They're not allowed to abuse the discovery process in particular as part of litigation. That's in Model 3.4D. We're going to talk about all three of these as we move forward. So let's first look at unmeritorious claims and defenses. So in this situation, there's basically two kinds of cases that arise. People claim that somebody was just harassing or causing them injury by someone else, whoever's submitting the unmeritorious claim or defense, that it's harassing or injuring the other person, and the person doing it is doing it maliciously. Typically, you're not going to get a sanction unless there's something more than just an inadvertent unmeritorious claim. It has to be done with some kind of intent to gain some advantage, something like that. So it could be to harass somebody, to cause them stress, to cause them fees that they have to pay the lawyer to respond to the case. Any of those types of things is going to be, especially if there's no legal merit to the case, if they have nothing to pin it on. I mean, if they're bringing a case that they believe in good faith and they have a legal basis for it and they're trying to assert a legal right that they have and prevail, well, that's what the system is for. But if they don't have a real claim and they're just using the legal system to harass or injure someone, then they're going to be subject to sanctions as an unmeritorious claim. Another option or another kind of situation that tends to evolve here is a claim or a defense to a claim that's unwarranted under the law. There's just no basis for whatever claim or defense they're asserting. They're just kind of making up some legal premise to try and say that they have a claim or a defense, but they can't cite anything. They can't point to anything in the law. They're just sort of arguing principles of fairness or something like that don't have a legal basis. That's going to subject them to this unmeritorious claim or defense sanction with one major caveat. They are allowed to do that if they can demonstrate a good faith argument that they're trying to change the law. So if they're trying to make a change in the law, obviously that means the law isn't already there. And so it would be sort of unmeritorious if the law is not there for them. But if they're saying this should be part of the law, and I'm going to assert it so that we can change the law, and I have a good faith argument to believe that this is why this should happen, this is the appropriate reason for why this should be added to the law, then those are allowed to go forward with that demonstration. As I mentioned before, people tend to do this when they're trying to gain an advantage. So if they don't really have a meritorious claim or a defense that they can really assert, then just submitting it to the court to gum up the system or take time or use the judge's resources or cause the other person to pay fees for their lawyers to have to respond and things like that, They're gaming the system to create some kind of practical advantage. And that's basically exactly what we don't want in the legal system. We want the legal system to be used properly, so that people, believe in it. It has a good reputation and it delivers the kind of results that we expect, and not to be used as a tactical or practical advantage to getting some other thing accomplished, like bankrupting someone or driving them out of business. Now, one of the things that arises is that because lawyers can't or can get sanctioned for submitting an unmeritorious claim, let's say, then now they have an obligation, or at least it would be very wise of them, to confirm the facts that clients bring in before filing actions um, based on the facts or the situations that the clients are describing. So if a client comes in and says something happened and the attorney comes to the conclusion that that client, should be compensated or can assert a legal right and has a available remedy, that type of thing, the lawyer should be sure to do some double checking that what the client is telling them is in fact accurate. At least some reasonable looking into and confirming the facts that the client is presenting so that they don't put themselves in a situation of bringing an entirely unmeritorious claim because nothing that the client told them was accurate. In the final bullet here, I already talked about it's okay to bring a claim like this if you have a good faith argument that you're trying to change the law. That can be couched, or that can be phrased as extending the law, modifying the law, changing the law, different words being used, but it's the same basic concept. So now we're going to take a look at discovery abuse. This is the second of the the three topics that we're covering tonight. Discovery abuse, hopefully all of you know what the process of discovery is. It's part of litigation. Somebody files a claim, the litigation starts, and one of the processes within litigation prior to getting to trial is that you have to work up the facts and you have to figure out and get the evidence that you need to put on your case. And so there's a process there called discovery where both sides are asking questions, asking for documents, things like that, called discovery. So an abuse of that process can be when one side asks a bunch of frivolous discovery requests. So questions that the other side might have to answer, sometimes called interrogatories, or document production requests. Just things that if they're sending those requests over and they're not related to the case, or they're not necessary to prove the case that the party is attempting to prove, they can be considered frivolous. And the underlying assumption is that they're probably doing so just to cause the other side extra work, extra fees, extra costs, delay the process, bury them in having to answer questions. And if those questions don't relate to what's necessary to help prove the case, that's going to be frowned on. A claim of discovery abuse could be made and sanctions could be levied. The same thing happens on the side with failing to comply with proper requests. So if somebody sends you a discovery request and it's reasonable and the questions relate to the issues in the case that the other side needs in order to present their case and potentially prevail, and you don't reply, or you reply with half the information, or a half truth, or things like of that nature, then you could be cited for discovery abuse. You have a legal obligation to provide the information requested in an interrogatory or a document production request if you have the information. That's part of our legal system. You can look up the rules of evidence, but you have a legal obligation to comply. And if you don't comply, then you could be cited for discovery abuse, probably also violations of some other rules of evidence. We already mentioned that this is put into ABA Model 3.4 sub D, but it's also in what I just mentioned, other statutes like rules of evidence. It could also be in court rules in the local court to wherever you're practicing. So if you are a litigation paralegal and you're practicing in certain courts, then you obviously want to know the rules of those courts. You look them up, you ask anyone at the court or anyone in your firm, where can I find the rules for a court for this court that we're working in? It might be a federal district court, it might be a local superior court, it might be something like that. You find their rules. And you want to make sure that you understand any discovery abuse rules that are in there. They're likely going to be modeled on Rule 3.4D as well. Look very similar. It's the same basic concept. But be knowledgeable about the rules that apply in your jurisdiction and the courts that you may be working in. So what do the violations that arise under discovery abuse tend to look like? Well, they tend to look like requesting or sending over questions to the other side beyond the scope of the case. So this is where you're asking questions that aren't really providing any information necessary for you to prove your case, but you're sending them over anyway. And it might be something like you are on the side of somebody who got hit by somebody else's car when they were driving. And so now you are filing a claim, a personal injury claim for negligence by the driver of the automobile, and you're looking for damages. And you send over, questions about the driver, let's say, that have nothing really to do with their driving of the car or anything like that. It's just, a bunch of questions that you're kind of just sending over there because you want them to be involved in having to ask them or answer them. And that kind of thing could result in discovery abuse. You don't need to know those things. You're putting an extra burden on that party to respond, and it's not relevant to your case. If they can prove that, you could be sanctioned for discovery abuse. Flooding the opposition with irrelevant interrogatories. This is where you do that, but not only with like a handful of questions, but with tons of questions. Now you're just flooding them with questions that don't really pertain to anything you need to know to prove your case, but you're doing it for purposes of weighing them down, causing them not to spend so much time on actually thinking about their own case and spending more time responding to your questions, running up costs, things like that. Incomplete answers to interrogatories, we talked about that earlier, where that's basically non-compliance. You aren't complying with the discovery process, that's going to be abuse, and you could be sanctioned for it. Requesting privileged information, you do that a little bit, you're not really going to get in trouble, but you should know better. You know what privileged information is. Your firm knows what privileged information is. If somebody asked you for privileged information, you would object. You really shouldn't be asking other people for it. You do that too much, it could result in a discovery abuse claim. Sensitive or embarrassing information, this is a little bit of a gray area. If it's really necessary to prove a point in your case that you need to prove in order to prevail, it's probably going to be allowable. But sometimes it's done for alternative motives, just to embarrass somebody or pull out something sensitive and put something in the public record that is embarrassing or sensitive. You don't really need it for your case, but it might just be to embarrass the person and then have it in the public record for all the public to see because they had to reply to your interrogatory and then it gets filed with the court. So if you're caught doing that and those questions don't relate to anything you need to prove your case, then potentially a claim for discovery abuse. Unfounded objections to discovery. Yeah, if it's either interrogatories or an in-person deposition or something like that that's being done, and you're an attorney or you're helping your attorney and you're giving them information and that attorney starts lodging objections to the interrogatories or the questions in the deposition and has no basis for lodging those objections, is just doing it because they either don't like the questions, are afraid of the answer, or want to gum up the process, or think that they can gain some kind of advantage just by stalling or making it uncomfortable or getting everybody stressed and irritated or whatever it might be, then there's a potential discovery abuse claim there. They have to have a good faith reason for their objection, and it has to be grounded or based in some kind of legal rule or legal right that they have. Okay, the third and last topic is just delay. And this is the strategy of just delaying the litigation or portions of the litigation or processes within the litigation to try to get to some kind of advantage. And it's not really substantive. It's not really something under the law that you're trying to gain. You're just trying to gain something by delaying. That was a lot in the news in the last couple of years, if you've been listening to what's been going on at the national level. But it can also happen just in a regular case where somebody's trying to delay, whether it's a pretrial procedure or whether it's the actual trial itself, they're trying to get some kind of advantage by just delaying. It could be something like witnesses might forget what they saw, or witnesses might become unavailable, moving, taking a trip, I don't know, whatever it might be. Or in like the really bad case scenarios, it might be that a witness passes away or something. Maybe if they're super old, somebody, or they're sick, and somebody starts, taking tactics to delay either getting through a pretrial motion or getting to trial to try to take advantage of that. That's not going to be allowable. And you can look in Model Rule 3.2, see how it's written in the model rule, and then check your jurisdiction to see what form of that they've adopted. There can be authentic claims for lawyers needing to ask the court to delay the case, or let's say the start of a trial. Could be that they're doing two trials at once. It could be a personal family emergency, death in the family, something like that. There are reasons that it could be appropriate, but just for personal convenience of the attorney, or some kind of other tactic like that to gain an advantage, frustrate the opposition by, let's say, failing to respond to their communications at all, right? So let's say you're working with the other side and they're sending you over not just like interrogatories, which you're legally required to respond to, but let's say they're sending you over communications to help negotiate certain aspects of meeting times, or questions, just informal questions between the attorneys, or setting up some other communication that they need to have with you, and you completely put them on ice and fail to respond at all. That can be, an abuse. If that gets too extenuated, that can be seen as a delay tactic, and somebody could make a claim that you're delaying. And if that's how the court sees it, you could be subject to sanction. Failing to appear at a hearing, that's even more than just a delay problem. You might get lucky and the court might postpone the hearing because you didn't show up if you didn't explain why prior. But you could also cause your clients to lose rights and other things like that. That's bad all the way around. So if it happens and the court extends it, the other side could say, you're just delaying by continuing to fail to appear. And if that carries the day, you could be subject to sanctions as well. Frivolous motion, right? This is similar to unmeritorious claims. You're in court, you're in a litigation, and to create problems for the other side, either to overwork their attorneys or stress them out or run up costs, all those types of things. I think you're kind of hearing the repetition in that, to know that's kind of the running up of costs, and overworking the attorneys and stressing out the clients, are all these things do those in different ways. So a motion to dismiss, a motion to suppress evidence, a motion to all these things, if there's no merit, if there's no real good faith reason for why you're filing these motions, then they could be considered frivolous, and you could get a claim for delay, inappropriate delay, and potentially be subject to sanctions. So when I'm saying I'm kind of putting it, on the legal team. Probably the lawyer is going to be the one that gets sanctioned, that kind of thing. But in some cases, we'll look at sanctions now. The sanctions could apply to other people. So contempt of court. Well, probably the attorney on the legal team would be in contempt of court, but other people can be held in contempt by the court if the court is giving them an instruction and they're not following it, and following the rules as part of the instructions. Courts can also, as part of their contempt of court citation, include a monetary penalty, and that can cost money, and then people have to pay it. Another thing that can happen as a remedy in this situation is the side that feels that they're being, abused by the unmeritorious claim, or the discovery abuse, or the inappropriate delay, they can just flat out sue for abusive process. If it's an unmeritorious claim, they can call it malicious prosecution. That's a civil suit. They can bring it in civil court. Obviously, they're not DAs or prosecutors, so these aren't criminal offenses, but the parties can sue for that. If something arises and catches the DA's attention in a case like this or in a story, and the DA gets concerned that somebody's abusing the process and that there's something deeper going on, might be a high profile case, um, something like that, a district attorney or a prosecutor could actually bring a case of the word is escaping me at the moment. Uh, could bring a case of ah, I can't remember. But there's a special word for obstruction of justice. Finally got it. They could prosecute for obstruction of justice if somebody is abusing the legal system so bad and it's gotten their attention, perhaps in some kind of high profile way with something that could be related to crime or something like that. So that's just a side note. All right, we've made it through the topics, the three main topics that we wanted to cover tonight. We've looked at sanctions and remedies, and now we're going to touch on our discussion question for the evening. So this is where we apply what we've learned. And today, it's Fanny Franks. And Fanny Franks, I'm going to assume is female for our discussion here, is a paralegal, and she specializes in litigation. And she works for a large law firm. And they have a case defending one of their clients, which is a giant oil refinery. And apparently there is somebody on the other side bringing a big toxic tort case. This might be a class action lawsuit. It might be a bunch of people that got together to sue this refinery. Somehow it got to be a big giant toxic tort case. Okay. So as an experienced litigation paralegal, Fanny is in charge of the document production and responses to discovery. So we talked about it a little bit earlier. Very common. George, who's one of the lawyers in the case, tells her not to answer about 2/3 of the interrogatories that have been sent over by the other side and to draft objections to the rest based on irrelevance and privilege. So what's happening here? So Fanny's law firm, Fanny and George's law firm, received a set of interrogatories from the other side. Who knows how many there are? Let's say there's 100. If this is a big case, could be more. But let's just say for purpose of this discussion, 100 interrogatories. So George tells her, don't even answer 2/3 of them. And the other third, draft objections based on irrelevance and privilege. It's kind of vague. He doesn't even specify which ones would be irrelevant or which ones would be privileged or something like that. He's just giving her this blanket instruction. So Fanny reviews all these interrogatories and sees that only 2 out of this 100 might be objectionable. So she's kind of thinking that George is doing this to kind of wear down the opposition, and it might be an ethical problem regarding discovery abuse, maybe even delay, maybe even both. So opposing counsel, turns out, is a small firm only handling this one case at the moment because the case is so big and its existence depends on winning, which makes it sound like it is a contingency case, and it currently has no other revenue. So why is that important? Well, that little tidbit there is important because it gives you a hint that George may actually be doing what he's doing to kind of wear down this client or wear down this opposing firm, as Fanny might suspect that he's doing. So what should Fanny do? Give me a moment to ponder that before I say what I think Fanny should do. Okay. So the first thing is that Fanny should obviously talk to George. I think it's completely appropriate. And this occurs over and over again in the discussions questions that we've had during the term, where since we're talking about ethics, something ethical comes up. And the question is, what does the paralegal do? And a lot of times the ethical issue arises because of something that's being done by the people that they work for, a lawyer, the firm, some version of that, and they're put into an ethical dilemma. And one of the things that we've been talking about throughout the term, and I hope that this is made sense for you, is that it's always a good idea to go to the person and ask questions and have a discussion in a very non-combative, non-adversarial, doesn't need to be confrontational. It can be just a conversation with some questions, asking for some understanding, very non-threatening. Makes it very easy. Uh, it, it it doesn't need to be a problem, and it can be totally appropriate, and it can help you in maintaining your ethical standards. So I would recommend Fanny goes to George and says something along the lines of, George, I see, I took a look through the 100 interrogatories sent over by whatever law firm, and I only see really about two that I can figure out we could lodge an objection to. And we have an obligation to respond to the other two-thirds. So can you help me understand, what the strategy is or what your thoughts are behind not responding and these objections for irrelevance and privilege so that I can better kind of grasp what I'm supposed to do here or how I'm supposed to do it or understand the reasoning that I'm supposed to be using in preparing or responding in this and just see how George responds. It's a very non-threatening question just to ask, what's your strategy here so that I can understand. And she can be very clear that, she understands what the ethical rules are and she wants to comply with the ethical rules. And she's trying to understand because she's seeing some imbalance here. And maybe George just opens up and talks about it. Maybe they come to a resolution. He says, yeah, that's not a good idea. Let's go ahead and, respond however is appropriate. And that could resolve it. Or maybe he doesn't answer at all, or maybe he tells her, look, just do what I told you, da 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 da. Who knows? But it is appropriate for her to be able to ask that, and everything lies in the way that she does it. So that would be my advice. Another thing that you can do as a paralegal here that can be very helpful is that you can, in advance of situations like this arising, maybe when you start working there, you ask them, hey, if I'm ever provided with work and I see kind of an ethical issue evolve and I attempt to talk about it with the person providing me the work, presumably an attorney, and I can't get any resolution or I can't understand the response, what do I do? Who do I go to? Who do I talk to in situations like that? And you can ask that before there's ever a situation that arises, and then and you can feel comfortable and confident in knowing the process is talk to George, and then if that doesn't work and you still feel like there could be an ethical violation that you'd be committing in following his direction, then go talk to whatever point of contact they gave you for when something needs to escalate. That could be another option. All right. A few weeks later, Fanny is preparing documents that will go to opposing counsel in response to document production. She notices that a key internal memo from an employee to management about toxicity levels at the site in question is missing from the documents that she's been working with. So built into this question is an assumption that she knows that there's a document that exists and that it's disappeared or, is no longer in the file. And she knows what it's about. She knows that it's about toxicity levels at the site in question. There's an implication here that that's going to be relevant to the case and that it would be important, not just a, irrelevant document missing. So what should she do that she now knows this? She's trying to respond to the request for document production. If she found the file or if the memo was in the files, she would have provided it. But now she knows that it was there and now it's gone. So what should she do about that? Okay. So first of all, it's completely appropriate for Fanny to ask around. There's George and other lawyers that have been working on the case, maybe other paralegals, who knows? But she can ask around, hey, has anybody seen this memo? So that's an obvious one. She's like, I know it was here. It's a memo about this. It's responsive to the document production. I'm looking for it. I can't find it. It wasn't in the file. And maybe that'll turn up the memo. maybe people will not know what happened to the memo. But it could turn up the memo because it could just be that somebody pulled it from the file, was doing something with it, and just hadn't returned it yet, but fully intended to. Or it could be that they forgot about returning it, and as soon as it was brought up, they said, "Oh yeah, here it is." Or could be uh, that they misplaced it, but they were able to find it. I don't know. But there could be non uh what's the right word? Non-negative, non-nefarious reasons for why the memo's gone. And so by just calmly inquiring about what happened to the memo, it might turn it up and it doesn't, no big deal, nothing needed to happen. She found the memo. Now, if none of that turns it up, then she is presented with a little bit of a bigger dilemma. Now she has to inform somebody, whoever this point of contact is at the firm for informing these kind of things. In this case, it could be George. She could start with George, just like she did before, and saying, George, the memo's missing. I'm, you know, we need to either disclose that we don't have the memo because I know that it was relevant to the case, or what are we going to do? Because we can't find it. And George may, respond. She could talk to the point of contact in the firm about this missing memo. At this point, when there is a memo like this that she's aware that existed and is gone and no one can find it, that's a concern. That's a problem for a firm losing evidence, and they can get into trouble if people find out that they've lost evidence. And it's not something that either she or the firm want to cover up because it could be discovered later that they did that, and then they would all be in a lot of trouble. So the firm should take it seriously, and they're going to have to figure out how they're going to respond to an important piece of evidence that was lost. And oh, by the way, it just so happens that the disappearance of that evidence probably helps their case or their client. And they're going to have to come up with a strategy for how to either disclose that or handle it in the appropriate legal way. It might be, a discussion with the judge, and then direction from the judge on what to do next. They could be, I mean, by being open and honest about it, that would be their best bet, and say, we didn't intend for this to get lost, but it got lost, and there's nothing we can do about that. We can't get it back, but and we'll improve our processes going forward, but we want to be honest and disclose that it isn't, that we don't have it anymore. And that if we could, we would find it and provide it. Something like that. But at some point, the firm has to take ownership of the way they're going to respond. And she doesn't want to be caught doing something unethical by just not responding and not informing the firm that a memo she knows to be within the files, relevant to the case, has gone missing. So that's the end of our discussion. That's the end of our class for this evening. Please turn in your assignment for week 15 on special issues and advocacy. And it's a writing assignment similar to this one with a fact pattern and questions. So you're very familiar with that format. And that will be our last assignment for the term. The only thing left after that is to take the final. And again, the final time. So if there is any scheduling issue, I've heard from a few people, we've made a few arrangements. If you have one, please email me in advance of the final, in advance of December 12th, so that we can take care of any accommodation or any different scheduling that you might need. So thank you very much. It's been a pleasure teaching this course during the term. All of you have been fantastic as students. I've appreciated all your participation, all the questions that you've had, the conversations that we've had at different times during office hours and other times, the emails that I've had and things like that. So thank you. Feel free to contact me in the future. Good luck with your next, if you're continuing on with Southwestern, good luck with your next term. If you're doing something else, or it's you're moving on to practicing or something else in your life, good luck with that. But it's been a pleasure being your professor for this term. It's an honor. And so thank you and have a wonderful holiday.